The material provided in this video is for general information only. It is not intended to provide legal advice or opinion of any kind. First Nation Matrimonial Real Property Law. Many First Nations are choosing to draft their own matrimonial real property laws. So, what is matrimonial real property? Real property is property that can't be moved, such as land or a family home. Matrimonial real property is real property that is shared by two people during a marriage or common law relationship. When a relationship ends, through separation or death, there are legal issues which impact how real property is divided and transferred. Family Homes on Reserves and Matrimonial Interests or Rights Act. Provincial property laws do not apply on reserve land. So the Family Homes on Reserves and Matrimonial Interests or Rights Act was enacted in 2013 to fill this legislative gap. FAM-MIRA provides rights to spouses during a relationship and after it ends, with respect to use, possession and occupation of family homes on reserve, and division of value of any interest that they hold in structures and lands on reserve. FAM-MIRA applies to both married couples and common law partners living on reserve, where at least one of them is a First Nation member, or an Indian, as defined by the Indian Act. FAM-MIRA does not have an impact on other family law issues, such as child custody, support, or personal property. How can FAM-MIRA impact you? Under FAM-MIRA, a court can decide who occupies the family home, can remove persons from the family home, and order the sale or transfer of the family home. The court can also grant emergency protection orders, and exclusive occupation orders. Emergency protection orders. EPOs are issued in serious, or urgent situations of family violence. When determining whether or not to grant an EPO, the judge considers a range of factors. Orders are issued for a period of 30 days, can be extended up to 90 days, and apply equally to First Nation members and non-members or non-Indians on reserve. If you, or someone you know is in a serious or urgent situation of violence in the home, please call 1-866-816-6555 to speak to a Justice of the Peace. Exclusive occupation orders. A court can order exclusive occupation of the family home to a spouse or common law partner. This order will require the other spouse or partner to leave the home. Under the Act, the Band Council is informed of any application made, except for emergency protection orders or confidentiality orders. Band councils may make court submissions, however, their viewpoint is only one factor the judge will consider. Although FAM-MIRA was developed to protect First Nations, there are a variety of unintended consequences, including the court having more powers on reserve, non-band member or non-status having potential occupancy rights on reserve, the potential of interfering with self-governance. To remedy these consequences, many First Nations are developing their own matrimonial real property laws. By developing its own MRP law, a First Nation can exercise jurisdiction over land and family real property matters. The First Nation can ensure that their law complements traditional laws, customs, practices and policies, and complements dispute resolution mechanisms. Many First Nations across the country have enacted their own MRP laws, most are in Mi'kmaq. Your community is well positioned to follow best practices from these laws, as well as create your own unique law. How the process works. The process requires extensive community engagement, and the law must be drafted with input from a variety of stakeholders to ensure the law is reflective of community values. The Union of Nova Scotia Mi'kmaq is organizing a series of engagement opportunities. So, how can you get involved in a community engagement opportunity? You can complete our online survey by scanning the QR code. Or you can visit our web survey link. For more information about local community sessions, join our Facebook group. Find us by scanning the QR code. Or, visit Facebook and search Eskasoni MRP.